two of your daughters told the police that they and their brother Stephen slept with knives under their mattress because they were so afraid that you were going to kill them all while they slept. So you didn't have to use force. You terrorized your own children, sir. So you know what it's like. And you turn around and you did it to your own daughter.
Yeah.
Did you violate more than one of your children?
And we are about to watch the parole hearing of a monster who did the unimaginable to his biological daughter. Now, this case was decided, the appeal was decided in 2012. He was given a 25-year sentence, but suspended after 20. And here he is up for parole. Now, this is one of the most atrocious, nastiest cases that we have seen. And I want you to keep in mind that we watch it, that the state of Connecticut considers him to be a low risk to reoffend because of that old trusty static 99 risk score that all 50 states in America uses. Just keep that in mind as you watch this parole hearing. And we are going to hear from the survivor the courage that it takes for her to get up here and stand up and drop a mic on this lousy sperm donor, because that's all he ever was. I'll unpack it with the details of the appeal at the end.
My name is Oral R. Haynes. My inmate number is 339578.
Thank you. This hearing is being conducted in consideration for the parole application of Oral Haynes, 339578. He is serving a sentence of 25 years, execution suspended after 20 years, and 10 years probation for sex assault 1 and 6 counts of sex assault 3rd. As of today, records reflect a parole eligibility date of March 15th of 25. There is victim input in this case. There is an offender accountability plan for this offender. It has been reviewed and shows that the offender has completed the following programs: sex offender treatment, voices, tier 2, and alternatives to violence. Utilizing the statewide collaborative offender risk evaluation system, the offender's score falls within the low range risk of recidivism. Utilizing the static 99R, the offender's overall score for sexual offense recidivism falls within the low range. Mr. Haynes, this is your opportunity to express to the board why you believe you should be granted parole. You may begin, sir.
Well, I've been in prison for a while. I've tried to be a good prisoner, tried to stay out of trouble. I wish the circumstances were a lot different than what they are, and I wish I could apologize to the parties that were involved. I hurt them, I hurt myself, and I blame nobody but myself for the offense. I had an alcohol problem, I had a drug problem, and pretty much, I'm looking for, a little bit of mercy and forgiveness and get a second chance to be a better person than I was, basically.
Okay, Mr. Haynes, thank you so much for that statement, sir. While we can appreciate your declaration of hurting yourself and the victim, we really need to discuss what it is that you accept responsibility for. It's my understanding that you've completed the treatment. Is that right?
Yes.
And so tell us what you did to this victim.
We had sexual encounters. There was never any penetration, but there were other types of sexual engagement.
And how old was your victim?
She was, when this first started, she was in 16, 17.
And so I thought that I read somewhere in your records, sir, that you said that it was consensual sex, or wait. Yeah, you said your daughter was 21 years old and it was consensual. So are you admitting today that this occurred when this victim was underage, sir?
No, like I said, I was on drugs and stuff. And
That's not what I asked you, though, Mr. Haynes. My question to you was very direct. Is it your position here today that you accept responsibility for sexually assaulting this minor child? That's a yes or no.
yes,
Thank you. And so why did you take this case to trial?
pardon?
Why did you take your case to trial, sir?
Why did I take my case to trial?
Yes.
Well, you know, I caused everybody enough pain and anguish. Okay, so I figured, you know, if I came into prison and got a bigger sentence, I'd get more help. So that's why.
So do you think you've received the help that you needed? So wait, so are you telling me that this was something that you did, like you're not a martyr, but like you did this to help your family so that you got the most time that you could possibly get for this crime?
In a way, yes, okay, but mostly it was for me to get the help that I needed to get away from the drugs and the alcohol.
Okay, but not the sexual assaults, just the drugs and the alcohol. So I'm confused, Mr. Haynes. I really am confused, sir. We don't have to go to prison for 20 years because we're addicted to drugs and alcohol. You have 24 counts of sexual assault third and sexual assault first. It says nothing in here about your being convicted for possession of narcotics or being, I don't see any conviction for any drugs, sir.
Like I said, at this time I was doing a lot of drugs. And
so are you saying that the only reason why you did this to this victim is because you were under the influence?
yes.
Okay. I mean, you're saying something completely different than the stuff that I've read about your case, sir. In fact, when you spoke to the parole officer in preparation for today's hearing, and she asked you about your crime, sir, you said to her that you never really forced the victim to have sex with you. Did you force this victim to have sex with you, sir?
No, I never forced her to do anything. So
okay. So this started at 9, when she was 9 years old, right?
No.
Okay.
No,
so
she was
10 years old?
She was a teenager, 13, 14.
That's still a minor, sir. And so what do you know after you participated in treatment about minors and their ability to consent?
I don't have anything to say.
Okay. So it's important that we understand, sir, that you're here today to be considered for discretionary parole. And as parole board members, our primary concern is public safety. And so one of the ways that we gauge whether or not a person has been rehabilitated is by their program participation, their behavior in the facility, their acceptance of responsibility for their actions, sir, and their ability to identify some of the things that they were doing when the crime occurred and how they can avoid those behaviors in the future. And so it's important because of the nature of your crime, sir, it's important that you're able to tell us what your understanding is about sex in minors and their ability to consent. I know that's something that you covered in your programming.
I don't know what to say.
Okay. All right. And so you said in your opening statement that you, if you had an opportunity, you wanted to apologize to your victim. What would you like to say? What would you say to her if she asked, Daddy, why did you do this?
Well, things weren't going too good, okay, and me and my wife, we were having troubles, okay, and my daughter was.
Mr. Haynes, no, I asked you about, you said you wanted to apologize to your victim. And so I'm asking you what you would say to your victim in an apology.
I just tell her I apologize for what happened.
What happened? You apologize for sexually assaulting her and taking her innocence away and all the mental anguish and physical anguish that she has encountered as a result of your actions. Yes. You apologize for those and you wish that you had a chance to do it over again and you wouldn't do this to her or anyone else. You were sick and that you needed help kind of thing. That's an apology. Not, what did he say his apology was?
Sorry for what happened.
Oh, okay. I thought so. Okay. All right, Ms. Turner, do you have questions for Mr. Haynes?
Mr. Haynes, the records that we have about your substance use, what drugs were you so heavily involved in?
Would you repeat that?
What were the drugs that you were so heavily involved in that you lost all sense of dignity and morality?
Well, I was doing a lot of marijuana, okay, a little TLC and alcohol, and
I think you mean THC.
Yeah, well, whatever. So it's like.
So you blame your years of repeated victimization of your own daughter on marijuana and alcohol, nothing else?
Well, I was sexually assaulted when I was young, so it's like, a lot of things happened to me, and I was going through a hard time. Okay, it's a lot of. My oldest brother passed away, and like I said, I was just going through a hard time. So.
These are all excuses, Mr. Haynes, for unspeakable acts of victimization that you perpetrated against your own child. Did you ever get any help for yourself? For your own sexual abuse?
No, I didn't.
Did you suffer? Did you suffer as a result of having been victimized?
Probably, yes.
So you know what it's like, and you turn around and you did it to your own daughter.
Yeah.
Did you violate more than one of your children? When my colleague asked you about force, and you really go out of your way to minimize responsibility, even today, your language was you apologize to the parties involved. And and you apologize for what happened. These were acts and choices that you made to manipulate, groom, and violate this child. And when asked about force, you said no, but the reality was in the police report that the two of your daughters told the police that they and their brother Stephen slept with knives under their mattress because they were so afraid that you were going to kill them all while they slept. So you didn't have to use force. You terrorized your own children, sir. I have no more questions, Madam Chair.
Thank you, Ms. Turner. Ms. Apple?
Yes. Mr. Hainess, during your sentencing, the judge referenced that he found you without remorse or regrets. Has that changed in the ensuing years since you've been incarcerated?
Yes, it has.
Can you talk about it?
Well, I regret that it happened, okay? And the only thing I can say is I wish I could go back in time and prevent it all, but that's not going to happen. So, and one thing I would like to add, okay, to this meeting is, my children have large imaginations, so I never threatened any of my children, never. The only thing I told my children is to behave, stay out of trouble, okay? Finish school, go to college, and get a good job. And my oldest stepson can vouch to that point. So that's all I got to say. I got to say no more.
In one of the reports that we read, it said that you like to spend your time making calls to your family. Who are you in touch with and who do you talk to on a regular basis?
Well, I talked to my sister, and I talked to my brother, and I talked to my son.
Any of your other children?
No.
Thank you.
Thank you, Ms. Apple. Now we're going to turn the hearing over to our victim's advocate, Ms. Vasquez. Mr. Hainess, your time to speak is now over. Please do not interrupt. Do not make any noises as the victim speak, okay? Thank you. Ms. Vasquez, good morning.
Thank you, Madam Chair. Good morning, Madam Chair and board members. I have on speakerphone the victim of the case, and she would like to address all of you directly. This is my apologies. This is your opportunity to unmute yourself. And when you're ready to speak, please do so.
Good morning.
Good morning.
Okay, I just want to touch base on a wealth of things. First of all, we didn't need to go to trial. It was offered a plea bargain, which he refused to take. I was told that he said, if I'm going down, we're all going down. So that's one of the points I'd like to address. There's another point that there was no penetration. In fact, there was. The fact that his son said that the children had active imaginations, that is untrue. I don't hear any remorse whatsoever for the actions and the extreme pain and suffering that has been caused as a result of this. I did not consent to go down on my own father. I did not consent for him to eject around my neck. I did not consent for him to penetrate me, although he's saying contrary. That did occur. There's just, I honestly don't have enough words to describe what's going on with things, but I will say that I believe, regardless of the age of the inmate, that they do in fact have shown one, May I continue?
Yes,
you may.
Thank you. I'm sorry. I thought somebody said something. So I think that the inmate will in fact reoffend. I do have fears for the community. I have had to relocate as a result of everything that happened. I have fractured relationships with other family members as a result of what happened and the outcome of the trial. I only communicate with 2 of my 4 siblings as a result of this. And I cannot go back to my childhood home and visit one of my siblings as a result of this. I've relocated 7 different times as a result of what happened to me. I have a wealth of different health conditions that I have to address. Mental health is a big thing. It's been a big thing. For me, the sentence that the inmate was given was not adequate because I have a life sentence now as a result of what he did. And I cannot press enough that he doesn't have any remorse and that he is in fact at a risk to reoffend. He cannot be honest in this hearing, and he was not honest in the trial and when he was interviewed. So that's about all I have to say on the matter because I don't want to get too emotional and make.
thank you.
Thank you. Thank you for your statement, Madam Chair and board members. This is all that I have for this particular case. Thank you.
Thank you. Thank you, Ms. Vasquez. So at this time, we're going to deliberate and we'll give you our decision shortly, Mr. Hainess. So prior to the victim's input, I did have Mr. Hainess denied discretionary parole. That has not changed with the victim's statement. I believe that Mr. Hainess has a lot of work to do on himself in his accepting responsibility and taking accountability for his actions and the impact that his actions has had on his family, not just himself. So I do not have him granted discretionary parole, and I would deny based on the nature and circumstance of his offense, the injury and impact to the victim and or the victim's family. Ms. Turner.
I concur fully. I would add inadequate evidence of offender change.
Okay.
I deeply concerned at the excuses that Mr. Hainess offered for his crimes and do not find him to be genuine in terms of his accountability, remorse, and change.
Thank you. Ms. Seppel.
I concur with the denial reasons put forward.
Thank you. I move that Earl Hainess 339578 be denied discretionary parole with no new hearing date based on the injury and impact to the victim and or victim's family, the nature and circumstance of your crime, sir, and inadequate evidence of offender change. He will not receive a new hearing. He will finish the remainder of his sentence with the Department of Corrections. Is there a second?
Second.
All in favor?
Aye.
All right, so Mr. Hainess, you were denied parole, sir. You'll receive all of this in writing. Good luck to you.
This concludes the hearing for oral case number 339578. All right, you're all set, sir.
Thank you, ladies. Have a nice day.
You too.
Please exit the room, Mr. Hainess.
You can exit. You can get up and leave. You can leave.
Yes, get up and get out of here, cockroach. That's what it is. You know, when you think you've seen it all, it's just unreal. But you want to know the travesty about this? I mean, if you could add more to it, it's that it doesn't even make a difference. You see, he's getting out on his full term date on 1/10 of 2026. He's getting out in a year. And that's it. He's going to be walking free, a low risk. We're going to go through the documents of this case. We have a beautiful article written where we can hear more from the survivor as if the survivor stands up to this sperm donor. We're going to go through the appeal and how the insanity of it, that the statute of limitations had run up so they could only charge him for the crimes that he committed. I guess more than a decade later. Look at him walk around there. I don't know if he's hiding from someone, staring out the door. Maybe there's someone out there to get him, right? You always wonder, how is it possible that people with these dirty jackets can just coast around in prison? But it seems to happen all the time, right? But here he is. Maybe he's hiding. That's all it's just so sick. Thank you, Holly, for providing the information on this case. I'm gonna pull it up while we watch him squirm. There's something satisfying about watching him squirm, and I'll read this while that happens. So there's the appeal, and then there's this article written in 2008, and it says, Vernon Man, Connecticut, sentenced to 2 decades in prison. He was sentenced to 20 years in prison and 10 years of special parole in Vernon Superior Court on July 25th for doing that to his daughter between the age of 9 and 23. His convictions was after only 3 hours of deliberation. Good on the jury. And meanwhile, we had to hear him talk about, I went to trial because I wanted a lot. It was like, what? That is, and you know, it will, like, I don't know if it went over the head of the parole board. They didn't even drill down on that. I mean, they did a fine job. You can tell they were disgusted by him, and it's satisfying. Now, this board is probably the best of the three: Turner, Berry, and Zoppo. I think they're pretty good. Well, Berry's hit and miss. They're all hit and miss. Sometimes you want to hug him, and sometimes, or often, you just want to scream. It was after only 3 hours of jury deliberation, but I guess give it credit where it's due. They did a good job being disgusted. Because of the statute of limitations in effect when the abuse was finally reported back in 2003, not 2000, this would have been 2003? Okay, I don't know. Hainess was only charged with sexual abuse occurring after the victim was 21 and not the childhood and adolescent sexual abuse, but it was factored in Hainess' sentence. Okay, it was 2003, sorry. The abuse started as inappropriate touching, she said, before progressing to further abuse, including intercourse. The woman also told jurors that she eventually began using birth control so that he would not impregnate her. Hainess, charged with 24 counts of third-degree SA and 1 count of first-degree SA, was found guilty on all counts. He denied the charges, then said that the sex was consensual between him and his victim. During his 2-week trial, can you imagine 2 weeks? 2-week trial. During his 2-week trial, the defense lawyer questioned why the woman waited so long to report the lengthy childhood abuse. Hainess was charged with only 2 years worth of assaults due in part to the state statute limitations. These sick psychopathic defense attorneys. He gets two defense attorneys. And can you imagine having to take that job? I'm sorry. I get that everyone deserves an attorney, but not everyone has to take these cases. I would say no. I'm not going to question. However, expert testimony revealed that the court of the victim's traumatic abuse often hide the details of their abuse from others due to deep sense of shame and responsibility, even going so far as to protect their abusers. After just 3 hours of deliberation, the jury convicted Hainess on 1 count of first-degree SA assault of 24 counts of third-degree assault, acquitting him of 1 count of first-degree kidnapping. Assistant State Attorney Elizabeth Leeming, who prosecuted the trial, said that his actions were one of the most heinous crimes one can commit. Never once prior to the trial or since has the defendant shown the slightest bit of remorse. And that statement is true to this day. The victim also spoke at the sentencing and said, "I'm sure you thought I wouldn't show up for the trial, that I wouldn't stay the course, that you still had control over me." Mic drop. You know who she reminds me of? She reminds me of the survivor who showed up to her momster's parole hearing and dropped a mic on her twice for what her mother had done, enabling her sperm donor, as she calls him, to do to her for all these years. You know what? As a matter of fact, I'm going to play a mic drop of that.
I should be at work right now. But instead of that, I had to go to my boss and ask for the day off because the woman who should have loved me is a pedophile. If she really is as sorry as she says she is, she should stop making me carve time out of my life to attend her paroles. Please, parole board, I ask you, don't grant this abuser release from prison.
Have you seen her parole hearing? If you haven't, you need to see it. I feel like these two women have that in common, just taking back the control and dropping a mic. It's incredible. We did a GoFundMe for her. I'll put a link to that in the description if you want to check it out. One of I think that our community raised over $10,000 for a GoFundMe, which is all about her being able to support her many siblings. She had many siblings, and she's the oldest sister, the oldest child, and she feels a need to support them as soon as they get out of foster care. At least when.
Hello?
They're all done, then.
Okay.
Hey, Nancy, yep, I'm all set. So whoever, it doesn't matter who's next.
So we have a code orange right now. We're not
Oh,
gonna
okay.
get the annex guys, but we have a guy in East 3, so we're gonna just grab him and bring him down ourselves.
Sounds good.
Serrano?
Yeah, whatever
So
works
it's
for
gonna-
you guys.
So it's gonna be Serrano, and then the annex guys, as soon as they get clear, they're gonna get dropped off.
Sounds good.
Okay? All
Yep.
right.
They
Thank
get out
you.
of foster care, they have a little bit of money to feel some independence and security. So the woman called herself the voice for those women who came forward to confront their abusers, even if their family or society ostracized them. Kesselbaum, however, argued for less jail time for the man he said was a good person and a good father. One who suffered from a background of parental. Shut up. Haynes' father was physically and emotionally abusive, and many of Haynes' behaviors mirror that of the father. Another factor in sentencing, Kesselbaum said, should be Haynes' life expectancy. Haynes, 52, is without work, with disability, and is plagued with physical ailments. 8 years for somebody in his position is a significant period of incarceration. Yeah, well, psychopath. Kesselbaum said after proposing a maximum 8-year sentence for Haynes, many of Haynes' friends and family also spoke during the sentencing in support of their friend and father. Can you imagine? Can you even imagine that people came up and spoke in support of this roach? It blows the mind, but this is something we see all the time. These birds of a feather flock together are never truer when it comes to these monsters. They are surrounded by enablers. Condition of special parole includes sex offender treatment and registration, no contact with victim or that. Okay. And here's the appeal. And look at this. It was decided November 2012, 13 years ago. And so it was an effective sentence of 25 years suspended after 20 years with 10 years probation. I really wonder what was the maximum legislation allowed, because if penalty of up to 20 years, the sentence was 20 years suspended after 15. It looks like she gave the max. The judge gave the maximum, because if they did not, it would just be insane. His total effective sentence was 25 years. No, you know what though? It wasn't the maximum because she suspended 5 years of it. So there was no reason for the judge to suspend anything. It's just insane. Jury trial. The facts are as follows. A petitioner engaged in sexual contact with the victim's biological daughter starting when she was approximately 9 years old. On at least 24 occasions between 2002 and 2003, he engaged in intercourse. On those dates, the victim was between the age of 20 and 22. On one occasion, the defendant compelled the victim to engage in the petitioner claims the sentence was inappropriate and disproportionate. Pursuant to the petitioner had an abusive father that was a special education student. The petitioner argues minimal criminal history and a sentence is excessive. The state argues the crimes were horrific. I agree. The abuse started when the victim was 9 years old, but because of the statute of limitations, the state could not prosecute these abuses. The petitioner has shown no remorse and takes no responsibility. The victim submitted a letter to the Division of Counsel from the therapist. The victim struggles with the aftermath of the crime. Yeah. It's the division finds there is nothing inappropriate or disproportionate with the sentence imposed by the trial court in this case. The petitioner, for an extended period of time, had intercourse with his daughter. He had shown no remorse for his horrific actions. The victim continues to suffer from the assault. And of course, they denied it. But, I mean, you shouldn't say, of course, you never know. But he will be out. He'll be out walking the streets. He'll have his same support group around him. He will probably have access to other victims, even though, the probation officer will say you can't, but it seems that he's in touch with at least one sibling, one of his son or stepson that may very well have kids now, and he is a danger. He is just someone who should never see the light of day. And the state of Connecticut, they view him as a low risk. Make that make sense. And with that, I'll let you go.
First of all, we didn't need to go to trial. He was offered a plea bargain, which he refused to take. I was told that he said, if I'm going down, we're all going down. So that's one of the points I'd like to address. There's another point that there was no penetration. In fact, there was. The fact that it's been said that the children had active imaginations, that is untrue. I don't hear any remorse whatsoever. I think that the inmate will in fact reoffend. I do have fears for the community. I have had to relocate as a result of everything that happened. I have fractured relationships with other family members as a result of what happened and the outcome of the trial. I only communicate with 2 of my 4 siblings as a result of this. And I cannot go back to my childhood home and visit one of my siblings as a result of this. I've relocated 7 different times as a result of what happened to me. I have a wealth of different health conditions that I have to address. Mental health is a big thing. It's been a big thing. For me, the sentence that the inmate was given was not adequate because I have a life sentence now as a result of what he did.